Friday evening for...
This meeting is being recorded.
Oops. For most of us, thank you, Ryan. We are so excited to have folks with us today. My name is Henry, going by the pronoun Stadium. I am the current Executive Director at ILGA Asia. And a warm welcome to our first webinar on strategic litigation and LGBTIQ rights in Asia. So together with the International Commissions of Jurists, Asia and the Pacific Office, in the next 2 hours, this webinar will highlight perspectives from South and Southeast Asia on bringing together anti-LGBTIQ laws, policies, and practices to court. And we have the lawyers with us who will be sharing best practices in strategic litigation, while the activists on the panel will talk about the role of access to justice and effective remedies in the promotion of LGBTIQ rights. And I guess for folks who are joining us today, let's learn and observe and also ask questions. How can we make the law work for our communities across Asia? I'll pass the time back to my colleague, Ajita Banerjee, Research and Policy Officer at ILGA Asia. Ajita, back to you. Thank you so much.
Thank you, Henry. Once again, a very warm welcome to everyone. My name is Ajita. My pronouns are she and her. I'm the current Research and Policy Officer at ILGA Asia. I've been a part of India's LGBTIQ movement for a very long time as well. And as some of us know, we've had a very vibrant movement that's been led by activists and lawyers alike. And strategic impact litigation has actually been quite useful in the way that we've seen rights come alive, especially after decriminalization in 2018. We have with us activists and lawyers both on this panel to share two sides of that story in terms of how petitioners come to the lawyers to sort of bring to light ground level realities and how lawyers make those issues sort of come alive in the court. So we're very interested in that conversation to happen in tandem. Yeah, we hope this is an enriching discussion. Please feel free to ask questions. And yeah, over to you, Darren.
Thank you so much, Ajita. So to introduce myself, my name is Darren Tan. I'm a legal advisor at the International Commission of Jurists, the Asia and Pacific program. Very, very delighted to be able to co-host today's webinar together with ILGA Asia. And today's session, as we all know, will be focusing on the issue of strategic litigation and how it can be a useful tool to advance the human rights of LGBT persons in Asia. And so before we start, I think maybe it might be helpful for us to just do a little bit of a primer on what exactly is the concept of strategic litigation to make sure that we're all actually on the same page. And so as we know, strategic litigation is a process that is commonly used by activists, by human rights defenders, by lawyers. It's the use of the law and legal processes to fight for social change, challenge unfair laws, policies, and practices, and seek judicial enforcement of rights in order to, safeguard and advance the human rights of LGBT persons. And so what we've seen in the region is that strategic litigation is about legal mobilization around specific cases that aims to empower marginalized groups, such as LGBT persons, and to protect their human rights. And so, for instance, when an LGBTI person has been the unfair target of harassment through legal processes, effective legal intervention in such cases can help achieve access to justice and an effective remedy, and also set positive precedents for future cases. Sometimes also we see that strategic litigation is used to bring larger structural issues before court. So it's not just about challenging specific legal harassment before the courts, but also about enacting change. And these forms of strategic litigation is often brought with the purpose of changing policies and other patterns or behaviors, especially when it comes to cases involving constitutional reviews of discriminatory laws, policies, and practices. Also, one additional thing about strategic litigation that it can also be used to increase the awareness of rights holders about their rights and the corresponding state obligations towards their realization. Because as we know, strategic litigation, whenever these cases are brought before the courts, there will be publicity, there will be buzz around it. And so sometimes the attention that's brought, to these issues can help mobilize conversations, discussions, discourse about these issues, and it makes rights holders more aware of what are their rights and how they can be enforced before judicial processes. And so we are very, very blessed today to have 5 different very esteemed speakers joining us. We're very, very lucky that they are giving us their time, and sharing their insights and knowledge with us. They've all been at the forefront of leading strategic litigation efforts, either through the courts, or through organizing and mobilizing human rights defenders. And so I think just as a bit of a context for all of us to think about as we listen to the sharing of all these different esteemed speakers, maybe we can have 3 key questions to think about as we listen to the insights and reflect on these questions. The first question would be for us to think about what makes strategic litigation an effective tool for legal and social change. The second question would be, what are some of the cons of using strategic litigation? And can strategic litigation actually backfire in certain instances? The third question would be, how do we maximize the impact of strategic litigation as a force for change, hopefully for the better, for the good? So with these 3 questions, I don't want to talk for too much longer because I think we're all very excited to hear from our speakers. And so first up, we have Arita from Sri Lanka, who will be presenting to us. Just as a background on Arita, Arita is the Equality Director at iPro Bono, a global organization improving access to justice, and he is also General Counsel at investment bank TWC. He was the former head of legal at the Ministry of Finance's National Agency for Public-Private Partnerships, a founding trustee of Education Initiative, Think Equal, and an investment banker at Clifford Chance and K&L Gates in London. Since moving back to Sri Lanka in December 2016, Arita also advised the Sri Lankan government on financial, economic, and education policy reform, especially around the Port City project. Arita continues to be a strong advocate for legal reform to strengthen the rights of women, children, and the LGBT community. For his work, Arita was ranked #1 Future Business Leader by the international newspaper, the Financial Times, in their 2015 Outstanding list, alongside Facebook founder Mark Zuckerberg and Lloyds of London boss Inga Bew, and a young role model by Sri Lanka Unites in 2021. And so I will pose a question to Arita for him to answer, and of course, answer the question, but feel free to also share anything else that you think would be interesting. So my question to Arita would be that you and your organization have been instrumental in ensuring the access to justice for LGBTIQ persons in Sri Lanka, including through the recent case where your organization supported the case filed against a lesbian woman seeking a declaration that she was mentally ill because of her sexual orientation. So could you share with us about the cases that you have worked on aimed at safeguarding the rights of LGBTIQ persons, and whether you think strategic litigation is an effective advocacy tool in Sri Lanka and other countries? Over to you, Arita.
Thank you. Thank you so much for having me. And I think it's a very opportune moment for us to speak about strategic litigation and the impact it can have, especially in the region here in Asia. So the case which you particularly brought up regarding the lesbian woman, actually in the last 2 to 3 years in Sri Lanka, we've been doing a lot of strategic litigation work around LGBT issues, and actually using that as an opportunity to challenge the narrative and the jurisprudence in the law, the existing jurisprudence and the existing narrative of what is meant by a term such as carnal intercourse against order of nature, what is meant by gross indecency between persons. These are the laws which we all share pretty much in former Commonwealth countries, especially in Singapore, Section 377 and 377A. We have very identical provisions, which is 365 and 365A. And unlike, of course, our counterparts in India, something which we haven't had is the benefit of judicial review of existing legislation. So you cannot actually challenge a law based on its constitutionality. However, the strategy which we took in that path was actually to challenge the interpretation of the law. And the application of the law, to bring in new jurisprudence and to challenge existing jurisprudence that actually carnal intercourse against order of nature or gross indecency between persons means homosexual or same-sex relations, So this particular lesbian case, actually what I can speak about is, so it was back in February this year. February and March this year, we got a report of an adult 23-year-old lesbian woman who was being locked up in her house. So this report actually came to us from her same-sex partner, and that she had been locked up in her house and prevented from leaving her residence because of her sexual orientation. Now, on top of the fact that she's actually 23 years old, she's also fully employed. So she was also being denied going to her employment because of her sexual orientation. So when this information was given to us, we filed, we sent lawyers to the police station to say there is an adult woman that is being forcefully confined in a residence, and that is criminal confinement. And when we informed this to the police escorted us to the residence, where we were actually able to take the woman out of her home and bring her to the police station for an inquiry. Now, at the inquiry, when the police asked her parents why her daughter is being locked up, the police said that she's being locked up. Her parents said that she's being locked up because she's a lesbian. Now, at that point, the police gave this woman an option saying, okay, either you stay locked up at home or we will lock you up in the prison in remand custody instead. And they were using Section 365A, which is a gross indecency offense. And unlike in Singapore, where it is only gross indecency between two men that's criminalized, in Sri Lanka, it's gross indecency between any persons that's criminalized. So it's actually a very wide interpretation of what it could mean. It covers same-sex sexual relations between men, between women, but it has also been used to include relationships between heterosexuals, opposite-sex partners, because of the wide ambit of including between any persons in the criminalization. So we challenge at the police station itself that actually this law does not criminalize same-sex relations and also does not criminalize being a lesbian. She was being imprisoned because she declared her sexual orientation as being a lesbian, not because she was found to be participating in any sexual activity of any sort. But the police is, of course, still adamant. And, in contexts and jurisdictions like Sri Lanka, the police also tends not to only enforce the law, but also enforce their own moral values. They become a cultural enforcer, as opposed to actual enforcer of what the law actually states. And the police confiscated this woman's mobile phone and her laptop, and she was using her laptop for her work purposes. So therefore, again, a denial of her right to employment. And they ordered that she be subjected to a psychiatric evaluation because of her homosexuality. Again, something which we objected to. The police also attempted to subject her to a physical examination to find evidence of homosexuality. Now, this is something which happens very commonly in Sri Lanka. We've had several cases where women and men have been subjected to anal and vagina examinations to find evidence of homosexuality. In almost 100% of the cases, actually, which I pro bono lawyers have been involved in, where LGBT people have been prosecuted, they have been subjected to forced anal and vaginal examinations. And this includes a judicial medical officer inserting their fingers inside the rectum of a man or a vagina of a woman or a trans man to find evidence of homosexuality. Now, it is the most absurd form of evidence sourcing, especially in the context of a lesbian woman. How on earth are you supposed to find evidence of homosexuality by inserting your fingers into a vagina? What are you expecting to find from this? These are virginity tests, basically. And it's torture, it's a form of torture. So we challenged those. And then what the police did was the police filed a case in the magistrate court against this woman, saying that she is homosexual and therefore she is a criminal, and that she should be subjected to these physical examinations and mental examinations. And what we did at the court was we said, look, the law does not criminalize homosexuality. The law does not mention the word homosexuality at all. You know, it's gross indecency between any persons. And we took the position that actually same-sex relations is not grossly indecent. And it is not unnatural. And there is a lot of evidence which shows that this is not unnatural. It is not grossly indecent. And we also brought in, you know, the Indian judgment where in the Indian court, the Indian Supreme Court really dealt with the issue of unnaturalness in its judgment and said, look, homosexuality is prevalent in almost all animal species, and it is just the natural form of expression of sexual orientation. So we used that argument. We also had a letter which was issued by the College of Psychiatrists in Sri Lanka, which said that homosexuality is not a mental illness. And therefore should not be classified as a mental illness. And then actually in that first point, what happened is the magistrate actually approved the conducting of a psychiatric evaluation and a physical examination. And we challenged the magistrate's decision at the High Court. And in the High Court agreed with us and then sent the case back to the magistrate court. And at that point, the magistrate agreed with us that actually homosexuality is not a crime, is not a mental illness, and therefore should not be subjected to psychiatric evaluation or physical examination, and dismissed the case. So that was actually the, quite a profound decision of the magistrate, where our argument succeeded at that initial attempt to persecute and prosecute an LGBT person. However, although we won at that level, the harassment of this woman by her family continued. And what we decided was to actually use the the Prevention of Domestic Violence Act to protect this woman from her own family. So the Prevention of Domestic Violence Act was initially designed to protect victims of domestic violence from against their intimate partner. But Sri Lanka's act is quite wide in the sense that it doesn't define a partnership as between only married spouses, so it includes unmarried, but also in the context of domestic violence, it includes your parents and your siblings could also be the perpetrators of violence. So we then we went to another court to file for a protection order for this woman from her own parents. And we said, look, she is being harassed and abused by her family because she is a lesbian woman. And it was actually quite outrageous in the sense it created quite a stir in the court, because never has a case of this nature been brought to the court, and never has the Domestic Violence Act actually been used to protect an LGBT person against their abusive parents. But the court agreed with us, and a protection order was granted at that time. So that's actually quite a successful case. That case is still going on in the sense we are now filing a fundamental rights case in the Supreme Court, saying that this woman's rights were violated by the attempted prosecution, by the police treatment of her, and therefore we are seeking a declaration from the court that actually same-sex relations is not criminalized, and that persons who are LGBT, especially homosexual persons, should not be treated as criminals. And for the court to order the police to issue a circular and instructions in that manner to other police officers to prevent this form of harassment and persecution. So we also had a similar case actually back in the year 2020 during the COVID pandemic, where 3 gay men were also arrested for homosexuality and prosecuted under Section 365 of the Penal Code for homosexual relations. And they were actually 3 gay men who were found in a private hotel room, fully clothed, having a drink with each other. So they're just like normal 3 friends who just happened to be gay. They were in a hotel room, they were having a drink, they were having a meal. Someone reported their behavior as suspicious, and the police decided to raid the room. I mean, they did not just knock the door and wait for the door to be open. They actually broke through the hotel room door. And what they did was they beat these defendants, these victims. They tied them up with wires. They then took them to the police station and whipped them with wires. And then they also subjected them to post-anal examinations. And at that point, when the cases were filed, what we did was we wrote to the Attorney General, because since 2014, Sri Lanka's Attorney General, which is an independent office, has asserted that discrimination against LGBT people is unconstitutional, and that the LGBT people are protected under the right to equality and the freedom from discrimination. So that was actually quite a positive statement which we had received from the Attorney General, and which the Attorney General makes these statements in international fora saying, you know, LGBT people are protected on the right to equality. So what we did was we wrote to the Attorney General saying, you make these statements at the United Nations saying LGBT people are protected on the right to equality, but here is the police arresting LGBT people and then subjecting them to what is essentially torture, and then prosecuting them. So at that point, the AG actually wrote to the court to say that this case will not be proceeding and they will not pursue prosecution. So those are sort of two instances of very successful, you know, either strategic litigation and strategic intervention. You know, the lesbian case was a case of strategic litigation in the sense of the kind of the arguments we used in defense in court, and the fact that we're going to the Supreme Court on this. And the three gay men being prosecuted for homosexuality is a good example of strategic intervention, where we wrote to the Attorney General asking the AG to intervene in a case because it conflicted with their position and their narrative. So I hope that this will be useful, especially for the South and Southeast Asian context, especially Singapore, Malaysia. I know Singapore is changing their laws now, but also Malaysia and Indonesia, where there are similar laws or where laws are being interpreted in a manner to criminalize, where we use new jurisprudence and new ways of arguing, not falling within the narratives, not to accept the narrative that we are criminalized, but to say, actually, the law does not mention the word homosexuality. Therefore, this is a matter of interpretation, and the interpretation is wrong. You know, there's another interpretation, which is that we're not criminalized, and we pursue that interpretation. So that's, so I hope this will be useful. Thank you.
Thank you so much, Arika. That was such a fantastic sharing. I think all of us learned a lot from you, and it's really inspiring as well to hear about the successful cases that you've, you know, not just a strategic litigation that you mentioned, but also strategic intervention. And I really, really appreciate the point that you made also about how, you know, sometimes you have to be creative about how you interpret current laws, given that in Sri Lanka, you know, the avenue of constitutional review, judicial review isn't available. So you have to be creative, right, about how you carry out your advocacy. And I think that, you know, the point about interpretation would be particularly relevant for Singapore, because we know that constitutional amendments are coming that are aimed at blocking strategic litigation of anything LGBT related. So I think this is a really helpful point for those of us from Singapore in this meeting today, you know, to learn from, you know, some of the successful cases that you've worked on over in Sri Lanka. So thank you so much. We'll move on now to our next speaker, Thilaga from Malaysia. And so as an introduction to Thilaga, Thilaga is a community organizer and researcher. Their work largely revolves around gender, LGBTIQ persons, and human rights. They are the founding member of several LGBTIQ campaigns and initiatives, including Justice for Sisters and Queer Lapis. Justice for Sisters, the group that Thilaga is with, has supported and initiated a number of constitutional reviews in Malaysia, including a successful review of Section 28 of the Selangor Sharia criminal enactment, which criminalizes sex against the order of nature. This law was successfully challenged on the basis of state overreach. So my question to Thilaga is that you have led and coordinated several strategic litigation efforts in Malaysia centered around challenging unjust laws and practices that discriminate against LGBTIQ persons. Can you share more about some of these cases that you have coordinated, and also discuss some of the best practices and challenges of coordinating such legal efforts? Over to you, Thilaga.
Thanks so much, Darren, and thanks so much for having me, folks. My name is Thilaga and my pronouns are they, them, and I'm with Justice for Sisters, and we'll be sharing a bit about the work that we've done in relation to strategic litigation or use of litigation as a strategy. So in Malaysia, just to give some context, LGBTQ persons face criminalization on the basis of our sexual orientation, gender identity, gender expression, and consensual sexual acts at the federal and state levels, right? In Malaysia, there's a dual legal system, and we have laws at the federal and state level. So this includes upgraded and amended versions of the colonial laws like Section 377, and similar to Sri Lanka, Malaysia's Section 377 is gender neutral. So it criminalizes all persons instead of just male persons. And the state and at the state level, we are looking at state Sharia laws, right? So combined, we are looking at a total of over 50 federal and state Sharia laws that criminalize LGBT people in Malaysia. I do want to note that the state Sharia laws are only applied to Muslim persons, and the jurisdictions of the state Sharia laws are far more limited than the jurisdiction of the federal laws. So I guess given the number of laws that criminalize LGBTQ people in Malaysia, so it's pretty self-explanatory why we, employ litigation as a strategy, right? But yes, I think, the fact that we live in a context of criminalization and increasing criminalization is one of the reasons why we employ this strategy. And also, I think, as what Darren mentioned earlier, I think in this context of criminalization, it is important for us to develop the rights framework as a whole and center the lived experience, our lived experiences, because often people, including the state, think that one, we shouldn't have rights, or two, we are encroaching into the rights of other people or the rights of the majority. Or lastly, we already actually have rights and we're already being treated equally, and we are asking for additional special rights, right? So in this context where the understanding of rights is completely warped and also skewed, so I think it's also important to develop this rights framework as a whole, right? And the last point that I made about like how sometimes even in the context of criminalization, people think that we are treated equally and we are asking for special rights also points to the fact that people don't understand what it means by criminalization as well as its impact, right? Because a lot of times for people, it's the human rights porn, right? Of like being arrested, being violated, having that tangible violence. And as we all know, coming from context of criminalization, we know that the impact of criminalization is far more insidious and it's far more hidden and systemic, right? So I think in this sort of context, it is important to use litigation to surface our lived experiences, facts, research, and also evidence, and create this body of evidence that we can present to the state or to whoever to review and take a look and learn. Okay, so Justice for Sisters, the group that I'm with, has supported a few strategic litigation cases and also many other cases. We provide legal support, and we also do human rights documentation. And I do want to say that a lot of the strategic litigation cases that we have mounted have had wider impact beyond the human rights of LGBTIQ persons. So the first case that we supported was between 2010 and 2015, where we supported a group of trans women in the state of Negeri Sembilan, which is an hour from the capital, who are facing harassment and repeated prosecution under Section 66 of the Negeri Sembilan State Sharia Criminal Offences Enactment, which criminalizes trans women on the basis of their gender expression and gender identity. In this case, we argued that the section, which is Section 66, was unconstitutional as it's inconsistent with the rights provision under the Constitution, in particular personal liberties, equality before the law, prohibition of gender-based violence, freedom of expression, and freedom of movement. So many of the arguments are similar to the NALSA case and also many other cases that we have seen in the past. But although we received a really good progressive decision at the Court of Appeal, But this decision was set aside by the federal court event in 2015 based on technicality. But interestingly, 2 years after that, in a drug-related case, in an the name of the case is Almanudo Atenza, the federal court judges noted that the federal court decision in the Section 66 case, the federal court had made an error in its decision. So in that sense, although there was a complex, in terms of even though the federal court set aside the decision, the progressive decision by the Court of Appeal, but a few years later, the federal court decision was seen as having made, the federal court judges were seen as have made an error in this decision. So there's a mix. So this case has a lot of complexity around it. But one interesting thing that I would like to point out is that following the decision, one of the significant things that we saw was a significant decrease in the cases of arrest of trans women, and also a shift in the laws that were used against trans women whenever the Islamic department would carry out arrests, right? At the same time, although the federal court decision was somewhat not favorable to us, one of the things that we saw was an increase of trans visibility and visibility of trans activism in Malaysia following the whole court process, right? So the second court strategic litigation that we supported was between 2020 and 2021, where Justice for Sisters, together with other LGBT groups, supported 12 men who were facing 2 charges in the Selangor Sharia Court, which is a state next to the capital. They were facing 2 charges. One was attempt, which was read together with sex against the order of nature, right? So this is similar to the case that was shared earlier. These were a group of men who were having a party in a private premise, and that party was raided by the state Islamic department. And as a result, they were arrested and charged 2 years later, right? The raid actually happened in 2018, but the charges were only brought to court in 2020. So in this case, over 16, as I said earlier, the Sharia laws are only applied to Muslim persons. So in total, 16 men were arrested at this party, and there were a mix of Muslim and non-Muslim persons. The non-Muslim persons were let go, whereas the 12 Muslim persons were charged under the state Sharia laws, right? And under the sex against the order of nature law, the court can impose a maximum of 5,000 ringgit fine, 3 years of prison sentence, and 6 strokes of cane, right? And of the 12, 5 people actually pleaded guilty, and they were sentenced to a fine, a prison sentence, and also 5 to 6 strokes of cane, right? And in this, against this backdrop of like some of them having been for just attempt of sex against the order of nature being sentenced to fine, imprisonment, and strokes of cane, which is almost the maximum fine, right? So against this backdrop, one of them actually, we supported one of them to file an application to review the constitutionality of the law. And in this case, what was interesting was that, we sort of tested this on a different, on state overreach, as like Darren pointed out earlier. The Federal Constitution of Malaysia clearly outlines the jurisdictions and areas of lawmaking for the federal and state government, so to ensure that there are no overlaps in lawmaking and such. So in this case, the challenge that we mounted was on the fact that the state had acted beyond its power or outside of its jurisdiction in enacting the law, right? So we were successful in this challenge, and the federal court, so this federal court decision has an impact on at least 16 liwat, or sex against the, or anal sex. Liwat is anal sex or sex against the order of nature. State Sharia laws all over Malaysia, yeah? The impact of it is quite huge and wide. So we also filed an application to review the constitutionality of the law, with the constitutional rights provision. But since, the federal court found the section unconstitutional, so we didn't have to go through with that. We are also currently supporting a review of a book ban, Gay is Okay from a Christian Perspective. And in this challenge, we really focused on unpacking the argument of public morality and what constitutes public morality, because I guess threat to national security and public morality are some of the two major arguments that are used against queer people. The High Court quashed the ban of the book. However, the High Court decision is currently being challenged by the Ministry of Home Affairs. So in some of the constitutional challenges that we've mounted, some common themes that we see is one, most of our challenges have been in relation to state Sharia laws. So this is quite different from the other laws that we have, that we see. And then two, they're usually connected to an active prosecution, right? So in the case, there is like a bunch of people who are facing caning, who are facing imprisonment, who are facing fines under the state Sharia laws. So this adds a bit of stress. And also then there's a lot of consideration of risk and cost, right? Because making the wrong move can actually have a detrimental impact on the people who are facing trials in court, right? Some of the challenges that we have seen, I have 5 minutes. I'm going to try to speed through this. So some of the challenges that we've seen is one, in actually just building the understanding of rights and access to justice among LGBTIQ persons, right? So prior to the challenges that we were mounting and like Justice for Sisters, the legal education and workshops were very reactionary and band-aid in nature, right? It's all about like, okay, what do you do in order to like get out of this arrest situation? Instead of really analyzing what are your constitutional rights and how is this law violating your rights? So I think through the constitutional challenges that we have mounted, we have also doubled down on community education so that then we can also shift the community mindset in relation to rights and access to justice. I also want to add that challenging Sharia laws adds a new layer of a challenge, right? Because there is an assumption that Sharia laws are God's law or they are divine laws that cannot be challenged. So even though these laws go through the same legislative process, but it has that extra divinity, right? Or there's a perception of that. So I remember when we first challenged the law, we also faced a lot of backlash because even the community saw us as like challenging Islam instead of challenging the law, right? And learning from the experience, again, we double down on community engagement and education. And also, I think in the context of criminalization and high level of rejection and exclusion by religion, self-acceptance among LGBT people is also extremely low. And that also has an impact on the way in which people perceive their rights and also see the kind of justice they deserve, right? So there's a lot of work that needs to be done in relation to self-acceptance, rejection, and all of that to get people to the point where, access to justice and realizing the rights is actually a thing. And together with this is one of the things that we also learned to do through this process. It's also code switching from activist language to everyday queer people language, right? Instead of saying things like, oh, we need to challenge this law. So then we sort of like use the language of you need to defend your rights in court and sort of unpack the role of courts, right? To sort of tell people that, yeah, this, if you go and plead guilty all the time in court, then the court is not doing its job, right? So I think there was a lot of unpacking and simplifying this activist language so that then people can actually like understand what we're saying. So just like other groups here, we also try to be as interdisciplinary, as intersectional, and refer to progressive case law as much as possible. So we've also cited NALSA and others. But I think building a good body of evidence also has its own challenges and risk and capacity issues, right? And I think having supporting advocacy activities are usually critical, because like in the first case that we mounted, it took us like 5 years to be in court. So we were able to roll out campaigns, media guides, we were able to do a lot of things to sort of support the case and also increase the visibility of trans activism and lived experiences of trans women. Similarly, as well in the other cases, I just want to end by saying that other good practices that we've identified is putting in place support and safety mechanisms. And I think this is a critical role that is played by civil society, because without the support and safety mechanisms in place, I think it's very difficult for queer people to feel convinced to go through on this journey, right? Otherwise, people feel like, they are just being, part of the queer agenda to like take down whatever and feel used in the process. Lastly, I think one of the good things that we have experienced is working closely with lawyers to ensure that a queer and human rights perspective is always at the center of this strategic litigation, and it is not just strategic litigation to advance just to advance things without centering our experiences, right? So I think it's also great that we've been able to get lawyers to engage in advocacy and learning activities together with us. All right, thank you so much, everybody.
Thank you so much, Thilaga. That was so helpful. Sorry for rushing you. This is truly incredible. And it also reminds us of very similar challenges that all of us have faced and engaged with in our jurisdictions. And I have to say, both Aretha and your comments, that some of the ways in which we've been dealing with these situations is also by understanding that while we're engaging in strategic litigation and strategic intervention, I feel like on the other side, law enforcement officials are also engaging in strategic harassment to some extent, in the sense of being creative with interpretation of laws that are not really about SOGI-esque issues, but really sort of opening it up and thinking how best we can use certain vague and broadly defined legal provisions to harass people and arrest people. Thank you for those remarks. That was really incredible. And we really admire the work done by Justice for Sisters. So thank you so much. We'll now move on to our third speaker, Jayna Kothari. Jayna is a senior advocate who practices in the Supreme Court of India. She is also a co-founder of Center for Law and Policy Research, which is based in Bangalore in India. Jayna's work is focused on constitutional law, gender and sexuality law, disability rights, and anti-discrimination law. Jayna was also a part of the constitutional challenge to Section 377, where she represented, amongst others, Akkai, who's going to be our next speaker, and also adultery, which were both decriminalized. Welcome, Jayna.
Hi, Jessica.
Hi.
Yes.
So Jayna, here's our question for you. So CLPR has been dedicated for a while to making the Constitution work for everyone. And one of the ways that you've been able to make the Constitution work specifically for the LGBTIQ community is through strategic impact litigation. And a unique part about your work has also been how the strategic litigation has been rather community-led. Could you tell us about the impact that some of these cases have had, including the challenge to Section 377, but also in the context of the cases that you've worked on in terms of right to education and right to employment for transgender persons? And if time permits, then maybe you can also tell us about the drop-in center that you've created at CLPR, where people can come in and seek pro bono support. Over to you.
Yeah, thank you, Ajita, and thank you everyone else for organizing this webinar. I think it's a great initiative to really discuss strategic litigation and the different forms it takes in the Asian context, because we usually look to, other countries like the US, South Africa, Canada, for strategic litigation or for some of the decisions, but we don't look at our closer neighbors. And also the challenges and approaches are so unique. I learned a lot from both Aretha and Thilaga based on their contexts. And I think, so I'll speak a bit about our work. And while in the Indian constitutional framework, we do have judicial review where we can challenge the constitutional validity of legislations and that is possible. It's still not easy. And so there are unique challenges that we've had to face as well. One of our first big cases was the 377 challenge. Akkai is here, and I'm sure she'll add to the discussion around the case. But we took up the decision to file a petition after the Nalsa judgment, and we faced a peculiar challenge because the constitutional challenge to Section 377, which is identical to 377A in Singapore and some of the other legislations in Sri Lanka, for example, carnal intercourse against the order of nature. And, the earlier challenge had gone to the Supreme Court and was rejected, was dismissed. So therefore, its constitutionality was upheld. And at that time, we faced a complete roadblock. What do you do? It was a bit like Singapore, right? You go all the way to the Supreme Court, and the Supreme Court refuses to intervene. But then the Nalsa decision came in 2014, which held that the right to gender identity and self-determination of gender identity was an integral part of the right to life, the right to freedom of expression, and the right to equality. And so we discussed with Akkai and other leaders from the trans movement that should we not use this as a way to revive the challenge to Section 377 and mount a new challenge in the Supreme Court. And so we filed in 2016 a new petition, and I think it was momentous because it was the first petition filed on behalf of trans activists, whereas the earlier battles for on Section 377, which were going on for almost 15 to 20 years, of course trans activists were involved, but they were not at the forefront. And I felt, and I'm sure Akkai will add to this, I think that was important, to bring trans issues as much to the forefront as issues of other LGBTIQ persons, and how Section 377 impacts transgender persons, especially in the context of their criminalization and harassment by the police. And so we filed this. And as you know, in 2018, we got the amazing Navtej decision, and the court gave quite a landmark decision, decriminalizing Section 377 in the context of consenting adults. And so that decision was a really momentous challenge. But then after that, I think that was one of the first steps for decriminalization. But then there were we took up many other challenges and other ways in which we took up litigation in both the Supreme Court and different high courts. And all of those kind of petitions emerged from the ground, really based on the need of the community. So for example, when COVID hit, we filed a whole range of petitions, both in the Karnataka High Court and other high courts, seeking for relief specifically for the trans community, because the trans community was really, really excluded and vulnerable because of COVID lockdowns and COVID restrictions, the loss of livelihood, loss of access to medical care, loss of access to rations. A lot of government schemes and rations were actually not available to trans persons because they did not have ID cards. And so we got a lot of important orders, especially from the Karnataka High Court and the Telangana High Court, which said that the right to food is a fundamental right. You cannot deny it to persons from the trans community for not having an ID card. You cannot. The government cannot insist on ration cards or ID cards. You have to give food. And so in that context, I think issues around the problems with ID cards, uh, some of them were addressed by the court. And so that was quite important. We had another similar case in the Madras High Court where the government, because of COVID, was giving out cash relief. And again, they needed specific ID cards, which were ration cards, which a lot of people from the trans community did not have. And so we said that this should be made available. They need the cash relief. And the government then, I remember responded that how do we know that they are really genuinely trans persons? And the court, and we told the court, well, I don't think we should be able to get into their genuineness or not, as long as they have any identity card, including self affidavits. That should be enough. And this cash relief was extended to the trans community as well. So this was a lot of the litigation was around COVID relief. And then post COVID, and a little bit prior to that as well, we've been taking on other litigation. Some of it is individualized. So, for example, a lot of members of the trans community need a change in their legal and educational documents. And we've had to file individual cases. And sometimes you find that even individual cases have a larger structural impact. So strategic litigation, I would argue, is not just larger public interest litigation, but in like a lot of individual cases, there can be far-reaching impact of the judgment. So one of the cases we filed for a trans man for change of his educational certificates. The Karnataka High Court, in fact, passed a broad order asking the government that they must issue a circular which would allow all trans persons to get their name and gender changed in educational documents, and they needn't have to come to court. So at least in the state of Karnataka, that circular was indeed issued. So, that has led to a larger reform for others as well. The other large case we have, filed in the Supreme Court recently, and it's pending, is on the issue of challenging blood donor guidelines. What was actually a result of COVID is we found out that despite the Navtej decision and the Nalsa decision, our Ministry of Health has rather antiquated and outdated blood donor guidelines, where blood donors, where there's a risk assessment made, and amongst the persons who are permanently banned from being blood donors are female sex workers and gay men and gay and bisexual men, I don't think lesbian women, and trans persons. So this class of persons, men having sex with men, trans persons and female sex workers are permanently prohibited from being blood donors without any scientific basis. And a lot of these similar blood donor prohibition guidelines have been revoked and challenged in other countries. The US, UK, Brazil, I think, had a recent decision. And a lot of them were not able to donate blood during COVID when their family members need it. And so we've challenged that, and I think that is important as well. And what it kind of revealed to us, I mean, this was brought by a very well-known activist from Manipur, Shanta Kurai, who's the petitioner, is that, you don't realize that in so many ways there are individual policies and rules and circulars of how the government operates. When it's only when you have to use them you realize how exclusionary and discriminatory they are. Even as lawyers, we wouldn't really be aware unless members of the community have experienced the discrimination and bring it up. So, so these are some of the important cases we've done. We also run a free legal drop-in center called the Translaw Cell at CLPR, where we try and provide free legal aid to all members of the LGBTQI community. And that's been, I think, found to be extremely useful by members of the community. And I think before I end, I have a couple of minutes. I think what, I would like to look at some of the questions raised. When does strategic litigation become an effective tool, and when does it backfire? I think it's an effective tool and it can be used positively when issues in many ways come from the community, or at least find resonance with the community. You need to build some kind of a campaign or a buy-in with this issue. It cannot be just an academic issue, and I think litigation needs a lot of support. The litigation team and the courts, I mean, you may have some orders in court, but if they're not implemented on the ground and there isn't activism and interest on the ground to implement it, it's just going to be a wonderful piece of paper with no relevance to anyone's life. And no impact. So you need work on the ground and work in the courts to go hand in hand. And where it does backfire, I think we've had certain failed attempts as well. Sometimes there are serious issues and we have a knee-jerk reaction to go to court because as lawyers we think the first thing is to go to court, and often members from the civil society groups also suddenly come to lawyers, and we don't do enough research, or we don't build the case enough because there is such an urgency and crisis that we immediately go to court, and often sometimes that does backfire. And and I've realized that sometimes these things that backfire, if a case gets dismissed, there's a much larger harm to the issue, to the movement, and it can actually bring a negative impact to the questions that we're trying to raise. So my, my learning has been that even if there is a crisis, look at other ways of addressing the crisis, but we have to go to court with preparation, with having, some work done where it's possible. So thank you.
Thank you so much. I can see some applause. We all have the urge to applause for all our speakers now. Thank you, Jayna. This was really helpful. And thanks for also ending with noting some of the pitfalls, just so we can all think about them as we go along as activists and lawyers. I think CLPR has also been able to carve out a really unique space in terms of strategic litigation and how you've been able to work in tandem with activists. And I think this is a really good opportunity for us to invite our next speaker, Akkai, who will shed more light on the way civil society has engaged with strategic litigation, especially after NALSA and also decriminalization. Because like Jayna said, this is only the first step. And there's been so much engagement with the law. And I really think that spaces like CLPR have also shifted some power in the sense of bringing activists in the court and take ownership of that space. So thank you, Jayna. And we will now invite our next speaker, Akkai Padmashali. Akkai, welcome. I hope you're here. I can't see you yet. Yes, there you are. Always a pleasure to have you. So nice seeing you again. So Akkai is a leading activist and a trans rights leader based in Bangalore, India, and is also the founder of her own organization, Ondede. She was also a part of the petition seeking to declare Section 377 of the Indian Penal Code unconstitutional on grounds of violating fundamental rights of LGBTIQ individuals in India, but also from the perspective of violating trans persons' rights as guaranteed by the NALSA judgment of 2014 that Jayna just referred to. Akkai is also an author and has recently published her own autobiography that we're all eagerly waiting for. Akkai, here's a question for you. You've been at the forefront of trans rights activism in India for a while, a part of ensuring that trans communities, especially those that face intersecting forms of violence and vulnerability, have access to justice. And you've done that through engaging with lawyers through strategic litigation. Can you share what has been your experience in terms of being an activist and a petitioner in some of the most significant cases in the country to advance trans rights? And have you also felt that there are risks and pitfalls involved in bringing strategic litigation cases in front of the courts as a civil society member? Over to you.
Yeah, thank you, International Lesbian Gay Association. I think we are a movement. We need to celebrate our movement. We need to celebrate our identities. We need to celebrate our voice, our sexualities. And we cannot or we should not compromise our identities or sexualities before the so-called social construct. I think maybe Ajita should correct your presentation. Akkai is not only a transgender activist. Akkai is a social activist. Akkai is a political activist. If tomorrow the lesbian, gay, bisexual, transgender, intersex, Jolkapa has been given that amount of privilege to live in a society of equality and justice, I will not accept that. Because until we address the issues of the burning in society that I live in India, which is known for its caste discrimination, which is known for its religious discrimination, which is known for its class discrimination, and like that, that could be ethnic, linguistic, your food, your dress, and stuff like that. I think we are facing in each and every section that amount of discrimination. Until we address the social construct or social burning issues, if they are going to give us the rights, I think I'm not ready to accept it here. I'm very clear. So that please correct that Akkai is a social and a political activist. Yeah. Well, second thing is about, I think I totally endorse what Jayna has said. I think we being in the streets as community, with our own identities, be it Panthi Satla Kothis, Jogapas, Marladi, Shiv Shakti, Jogta, Akwa, Nirvan, Hijras, double deckers, bisexuals, men, bisexual women, lesbian women, understanding gender identities according to gender people, intersex people, queer in that per se. So we give multiple definitions and identities for people to understand in our own identities. I think now the recent trend that we have seen is that people need to be addressed when it's come to the gender pronoun as they, them. I think this is something that the world is really looking forward to. Number two, the world is also a bit confused. How do we address these people? How do we understand the issues of unspoken section of society? Coming back to India, I'm coming back to my own state, Karnataka and Bangalore. I think the whole movement has begun from Bangalore. The activism has begun from Bangalore. The voices have been begun from Bangalore. The collectivization, the mobilization, the empowerment process, agitation, fighting against the state, fighting against your social notion, fighting against your conservative laws, conservative acts, be it that you could be eunuch, to the Criminal Trials Act, to the Section 377, to fighting for your identity. It was not so easy. And we as movement have never expected that this law shall be changed in such a very, fast or faster movement. But today we have seen that yes, it has happened. I think in India, if you see any other movement, that be it the women's movement, we are still struggling for the implementation of 33% reservation in parliament or in any such electoral, like politics. Number two is about people who are still struggling to understand the perspective on age of consent. The child rights movement are still agitating as a movement. How do you bring up the age of consent as an issue before the floor? The third thing is about the youth rights. And what is youth rights? The youth movement is in the process of understanding what is youth and what are the challenges of youth. I think if you compare to other movement and the sexual minorities movement, I think we are much faster than any other movement because the activism, the voice is very strong. Since 30 years, we were fighting, though the fight has begun from Delhi, Voices Against the 77, though that was active and inactive. The active part in 1998/99, I think the Bangalore took up the entire responsibility of mobilizing people to fight for our identities, to fight for our dignities. But today, I feel so privileged. I feel so happy to live in Bangalore or in the state of Karnataka or the entire southern part of India. We say the southern part of India is much, 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 much more liberal, much, much more secular, much, we have freedom if you compare to the north part of India. Here the politics of many, many human values or human responsibilities or human perspectives that shall come to a platform to debate and discuss what are we as human beings. I think building as a sexual minorities the last 24, 25 years, it was difficult for us to gain any sort of support from other movements. But today, the movement is standing with the sexual minorities community. That could be any, like any movement that could be the religious minorities, the class minorities, or the caste minorities, or any other section of society, or with the sexual minorities. At the same time, we are also being part of that movement. That is all about building a movement of convergence, of understanding the issues of people's issue than your politics. I think my existence is an identity. My existence is a politics. And how do I take that language to every table that I travel around? I think the 30 years or 25 years of struggle, I think what we have done today, this most Supreme Court Constitution of India's Supreme Court bench has really observed in favor of the community, knowing that the legislature, the executive, and the judiciary, I think the whole movement was kept so much of trust on the judiciary of this nation. I think the judiciary has really heard the voices of our people and which has said we are no more criminals. I think understanding saying that from 1860s to 2009, we were criminals. 2009 to 2013, we were decriminals. 2013 to 2017/18, we were made as recriminals. 2018 onwards, we are no more criminals. I think the whole fluctuation that has happened as a movement, as agitation, there's voices in the grassroots, the communities who are being vulnerable because of our identity, because of our profession and stuff like that. But finally, lawyers like B.T. Venkatesh, Arvind Narayan, Jayna, Kothari, and very other few lawyers like Vivek Diwan, who took up this entire responsibility, challenging before the Constitution bench and said, we are no more criminals and we are definitely part of India. I think to bring such a huge verdict, but unfortunately that the parliament process, the legislature system needs another dimension now. I think the real activism has begun from 2018. The first thing was about how do you get your recognition before the law on the statutory. Now we have got that statutory, and what is next about the statutory? Now it is about be it the political participation, to join any political party that is very open and accepting the issues of sexuality, gender, and human rights. The third thing is about how do we be part of such policy-making decisions or any sort of political decision that we are going to make. I think that should be the next front of our movement across the globe. I hope many of you might have been also seen my interaction with Obama. I think I bring a global perspective before the Miss ex-president. I think that voice has really going so wide and wide and wide, and people are now calling me and the organization and the movement here to be part of such international forum. I think this is something building about solidarities, building commitments, building responsibility. At the same time, where is money? Where is funding? Where is the grant? What happened to to your FCRs? What happened to your 12As and ATGs and stuff like that? I think as a movement, we are really struggling to raise money to build up our activism, to build the next generation of leadership. I don't mention second-line leadership. It's about building leaders for the upcoming movement. Definitely, they should take up this issue, and we need to play a vital role in supporting and nurturing and nudging people's issue, especially our issue, without compromising any such. I think I'm sitting before Dr. B.R. Ambedkar, who has written this, like Indian Constitution. I think whatever the values that he had taught us through the constitutional pages, And definitely next to Gandhiji, where we fought in such a non-violence manner, I think today we have seen that success, and this success shall continue with all the support of you people across the globe sitting here. And I'm so thankful to ILGA for giving this space and opportunity. Namaskaram.
Thank you so much, Akkai. So informative and eloquent as always. We'll move on to the next speaker, but we'll come back for a round of Q&A after that, because some of our speakers do have to leave now. So should we move on to the next speaker, and then we'll open it up for Q&A. Please post your questions on the chat, and feel free to mention your organization or collective or country of focus or origin if you need to, so that our speakers can also maybe respond accordingly. Thank you so much, Akkai, and we'll move on to our last speaker for the day.
Thank you, Ajita. So I have the privilege of introducing our final speaker. Swang is a partner at Eugene Durasingham LLP. He has extensive experience in public interest litigation related to LGBTI matters, including the 377A constitutional challenge and a judicial review claim related to a transgender couple whose marriage was voided. Swang has interests in civil and criminal procedure and has published in both of these areas. Recently, he co-authored the annotations of Criminal Procedure Code 2010 published by LexisAdvance under the Annotated Laws of Singapore. He was also a contributor to the book Same But Different Legal Guidebook for LGBT Couples and Families in Singapore. So welcome, Swang. Very happy to have you join us. The question that we will pose to you would be about strategic litigation in Singapore. So the Singapore government recently announced its plan to repeal Section 377A, and I think the text of the repeal and the constitutional amendments coming with it have already been made public. And for those of you who don't know, even though I'm sure most will know, Section 377A criminalizes consensual same-sex sexual conduct between men in Singapore. And Prime Minister Lee Hsien Loong indicated that there was a significant risk of 377A being struck down on the grounds that it breaches the equal protection provision in the Constitution, following the Court of Appeal judgment in February 2022 challenging its constitutionality. So could you share with us a little bit more about your experience working on that case, the Tan Seng Kee case, and other LGBT-related cases, and what you think about the future of using strategic litigation to advance LGBTI rights in Singapore? Over to you, Swang.
Thank you very much. I truly have the privilege of having been able to act in these cases. Another privilege that I have had is that there are many, I think there are quite many members of the trans community in Singapore who usually need their names changed. I think I'm a resource in the community for I guess a supportive lawyer who would just do these deed polls in a pretty fuss-free manner. So I'm very much honored and privileged to be able to play my very small role in the LGBT community with respect to legal matters. My involvement in public interest litigation related to 377A and broader LGBT issues actually started with when I was in undergraduate school, when I was in undergraduate studies, about 2010, which was around the same time, I think, as the first instance NAS Foundation case decision in was it the Mumbai High Court? I think that was 2009. What happened was then that in 2010, there was a plaintiff, there was a person called Tan Ning Hong. He engaged in intimate conduct with another man in a toilet in a shopping center. He was arrested and detained and investigated under Section 377A. Subsequently, these other famous public interest, or rather the most famous public interest litigator in Singapore, which is Mr. M. Ravi, acted for him and intimated that he was going to challenge the constitutionality of Section 377A for the very first time in Singapore's history. In fact, Mr. Ravi was instrumental not only in bringing that challenge, but also a whole series of other constitutional challenges that pretty much brought about a sea change in Singapore's constitutional law. So I think that's quite an interesting topic with respect to public interest litigation, because I think there's intersectionalities, because I think this host of constitutional challenges were not just related to LGBT, but also to death penalty and other matters, and it really brought about a big, it wasn't an evolution, it was a revolution in Singapore's constitutional law. Although, of course, I mean, in comparison to other countries, our evolution is quite conservative, as you could say. But anyway, what then happened after Ms. Ravi intimated this intention to challenge the Section 377A was that the prosecution did a bit of a clever thing. What they did was they decided not to charge the person with 377A. Instead, they changed the charge to a generic charge for public indecency that's gender neutral, and it's under the Miscellaneous Offences Act. And then they applied to strike out the case for lack of legal standing to sue. It went on first instance before a registrar. It then went to a high court judge, and at both instances, the court indeed struck out the litigation by saying you have no legal standing to challenge 377A because you are no longer charged under 377A. It then went to, he then appealed the striking out to the Court of Appeal. The Court of Appeal heard the matter in November or October 2011, and they reserved judgment for almost a year. It was a very long time. When they released the judgment in 2012, this is, I think, the true thing that really opened the gates to at least public interest litigation in this area. The Court of Appeal held that Mr. Tan did have legal standing to challenge constitutionality. They said that he was actually arrested, investigated, and detained pursuant to 377A. So therefore, he was injured under 377A, even though he was not eventually charged under 377A. But the Court of Appeal also made a broader ruling to say even if he hadn't been investigated, detained, and arrested under that law, the very fact that he is a member of the community and he has to live under the shadow of 377A also gives him an independent ground to assert standing. So that opened the gate, and that allowed Mr. Tan to move on to the next substantive stage, which is to substantively challenge the constitutionality. Of course, that also opened the gate for other members of the community who have not themselves been arrested or investigated to challenge the constitutionality of the law. I'm not sure if you are aware, but I'm sure it's quite well known that at the same time as the government decided not to repeal 377A in 2007, the government made this sort of promise not to proactively enforce 377A, and therefore prosecutions under 377A became extremely rare, which was why this decision on standing is so important, because without this first decision on standing by the Court of Appeal, really all the future constitutional challenges couldn't have happened. So that all those went to substantive hearings. In 2013, it failed substantively. It went to Court of Appeal in 2013, 2014. And this is a very unfortunate coincidence at a time. 2013, I think, was Suresh Koshal. That was the Indian case. And that came out in a very bad way. And it was followed up very shortly by our Court of Appeal decision in Lim Meng Suang in 2014, where everything was just dismissed entirely. Very disappointing. Fast forward then to 2018, where you had your decision, NAS Foundation, right? 2018, which overturned Suresh Koshal. At that time, I've been working under this firm, Eugene Turisingham. At the time in 2014, what Eugene had in mind was he wanted to wait about 5 years from 2014 Lim Meng Suang decision to challenge Lim Meng Suang decision. Okay, so 2018 by then was about 4 years afterwards, but then your decision came out by the Supreme Court. So Eugene was like, okay, let's do our thing 1 year early. It's 4 years, but let's challenge Lim Meng Suang. So he got a friend of his to be a plaintiff, and then we challenged the constitutionality. So litigation was brought in 2018, and then after that there were 2 other teams, sorry, I think I was just told it's not NAS Foundation, it's Navtech Singh Johar.
Yeah, the
2018
2018
decision.
Supreme Court case. Yeah.
Ah, great.
Sorry, you didn't
Yes.
want to.
But certainly we were looking at that decision, like the 200-page case, okay, which really excited us. So we brought litigation. It was not really the most, okay, the activism was quite coordinated. The legal thing was actually not the most coordinated, to say, but it actually turned out in a pretty good way, because what had happened then was that there were 3 teams of lawyers that each acted for respective plaintiffs, and each of us ran a slightly different case theory. And in the end, it just ended up with really all the angles covered in terms of constitution, whether it was a breach of Article 9, right to life, a breach of privacy, breach of freedom of speech, breach of equality, everything. Okay, so it went to first instance, and I suspected we lost. It then went to the Court of Appeal, and the Court of Appeal hearing was in January 2021. Okay. That hearing was quite curious, because normally, so there was a hearing before 5 judges. Normally, when we go before hearings in the Court of Appeal, we pretty much know where their direction is headed, and we pretty much know from the way they ask questions whether we will win or whether we will succeed, whether we will lose. This was quite an interesting session, this session in January 2020, which was, January 2021. Where there appeared to be genuine disagreement between the judges. Okay, the Chief Justice suddenly mooted this possibility of can we not decide this case on a basis that the government had already promised? Can we not elevate that promise into a legally enforceable undertaking called substantive legitimate expectations, such that not only is it a unenforceable promise, it's a totally legally enforceable promise that if you were prosecuted under 377A in breach of the undertaking, you will be entitled to file judicial review to challenge the prosecution. So in that sense, you shouldn't be at risk anymore of prosecution, therefore no more standing. And then you call it like a declaration of unenforceability of 377A, which we have never heard about. The government didn't run this argument. We didn't run this argument. Nobody ran the argument. 2 other judges sounded a bit skeptical to this point. They seem to be saying, but if 377A is constitutional, it is constitutional regardless of the undertaking. If 377A is unconstitutional, it's also unconstitutional regardless of the undertaking. But anyway, that ended, and then it took more than a year before the verdict came out. And of course, when the verdict came out, everybody was, I guess we kind of knew where the direction was headed. So the decision came out in the way that the Chief Justice expressed it, except that while they said they didn't want to decide the substantive issues, they did put quite a strong signal regarding the equality clause, saying that if they were forced to decide the issue, they may well actually really strike it down as unconstitutional. So I have 1 more minute left. I guess that left. Oh,
You have 5 more minutes left.
Oh, do I? Okay, great. So yeah. So with that, then we had that decision. It was mixed feelings, I guess, when we saw it, because obviously we lost, so we didn't. We were disappointed. But then it seemed pretty, but then the language of this decision was very different from the language of Lim Meng Suang. Maybe it's a bit like your case and Suresh Koshal, because Lim Meng Suang was extremely dismissive. But this case, this particular Court of Appeal case, it sounded like the Court of Appeal was just trying to sound more inclusive for the LGBT community. It sounded slightly more, I don't want to call it apologetic or something, but trying to just mend some bridges, that sort of thing, okay, with the community. Then of course we were very pleasantly surprised to hear the very recent developments that have culminated in these very recent bills in Parliament, where where government says that they would put forward legislation to repeal 377A, and that they directly attributed the reason for that to our the three sets of litigation, saying that if it goes forward to another litigation, there will be a very real risk of it getting struck down. But of course, it's a matter of, I guess, mixed results also, because together with that, they have to also take into account the interest of other conservative elements of society. So then they put forward amendment to the constitution. So the amendment to the constitution proposes that so it isn't a constitutional amendment to include the definition of marriage within the constitution itself. So what I thought was that they would define in the constitution marriage as between man and woman, but instead what they did is to say a parliament will have full constitutional power to define marriage, and whatever it is parliament decides to be valid marriage, it shall not be unconstitutional under the constitution, nor shall it be legally challenged on any basis. So I guess it's a bit like a constitutional ouster clause. So will this constitutional amendment be effective? I guess that's a topic for another litigation. So I suppose coming back to the theme of strategic litigation, I would say that all of this really wouldn't have been possible if not for the start, which is the 2010 to 2012 litigation on standing, which is Tan Hong's litigation. And that itself may perhaps not really have been possible if not for the whole intersectionality of really the various other constitutional challenges that were happening at the time, also pretty much all brought by Mr. Ravi, related to various areas, which included constitutionality of the death penalty, the extent to which prosecutorial discretion could be legally challenged. There was a issue on by-elections where and the court was, so it coincided with that, and it also coincided with judiciary at a time, a judiciary that while still dismissing the constitutional challenges on the merits, were becoming receptive, or rather receptive to lawyers mounting arguments. So it was really a confluence of factors that began in late 2000s, 2008 onwards, which was you had Mr. Ravi, which was starting to put forward these constitutional challenges. You had the courts, which although still dismissing them on the merits, was not as dismissive as they were back in 2005. In 2005 and before, they were basically saying, this is a non-starter. 2009 onwards, they were totally, they were saying, please argue these things. We want to hear these things, and we want to talk about constitutional law. Although, we will kind of dismiss your case on the merits. So, a host of factors. So I think that concludes my talk.
Thank you so much. That was really helpful, and thank you for drawing from other jurisdictions. That was exactly the aim of this webinar, and thank you to all the speakers for having done that very successfully. So we've come to the end of the webinar in terms of the speakers having made their remarks, but we do have some time for Q&A. Feel free to drop your questions in the chat box still. Since we don't see any questions yet, Darren and I will use this space to ask our own questions, which we're very excited about. And the speakers could also use this time to ask each other any questions if they have any. I'll maybe start, and my question is to Thilaga. I was just wondering if you could reflect on just the kind of strategy and decision-making that goes behind choosing what issues or cases we take to court and which we tackle as civil society. And if there's any strategy that goes behind thinking through those things collectively as civil society members and lawyers together.
Thanks so much. I guess for Justice for Sisters, because we do provide legal support, so so then we do get a whole lot of cases that come, we do get cases that are referred to us or come directly to us for support, right? So in that sense, then we do get to see a pattern of cases, like in terms of what is more popular and where we can sort of see potential in terms of you know, doing community education or just campaigning and things like that. So for example, like and also I guess like the other factor is usually has to do with the applicant themselves and the persons who are involved and their readiness and the kind of support system that they have in sort of mounting a challenge, right? So for example, in the book ban case, we were, you know, which was out, yes, we were doing some freedom of expression monitoring around censorship and things like that. But it was really outside of the kind of cases that we were working on at that moment. But it was really interesting because the opportunity sort of presented itself in a great way, that the publisher was up for challenging the ban, and also the author, who is somebody who is like extremely out and also not living in Malaysia at the moment. So then that added a lot of, I guess, security blanket for this person to sort of challenge the ban, right? Given the nature of the ban itself, like it's a book about Christianity and homosexuality. So I think there are different factors that go into play. I think one of the other biggest factor is the kind of activism that civil society or the organization or the LGBT movement as a whole is doing at that moment. Like, for example, decriminalization is like the bread and butter issue for some of us. So then, like, I guess, you know, it just fits within the kind of activism and the kind of evidence that we're building and all of that. Yeah, I hope I'm answering your question.
Yeah, no, absolutely. Thank you so much. Did you have a follow-up?
Yeah, I mean, thank you so much, Thilaga, for sharing that. And I think it's also important for us to try to think about the different areas, right, in which we can challenge discriminatory laws, because discrimination doesn't just occur through criminalization, even though I think that tends to take the center stage and that tends to dominate, you know, conversations. But we know that the livelihoods of LGBT persons extend beyond just criminalization, right? It goes to education, housing, food, you know, which is where I think that there is a lot of good, you know, good practices coming from India, you know, that I think the rest of us can learn from as well. You know, so, and I think the book ban case is also very interesting, right? Because we don't usually consider FOE issues, right? Freedom of expression issues when it comes to LGBT issues, you know, even though we know that censorship of LGBT expression, information happens regularly, you know, especially in countries where spaces are particularly queerphobic, you know, and a lot of these restrictions are now extending to online spaces as well. So thank you so much for sharing about that. Yeah. I guess I can pose another question just to keep the ball rolling. I guess I can pose this question to Swang. So thank you so much for your sharing. And I think, you know, it's really incredible to see that trajectory of litigation happening in Singapore and how it eventually resulted in the repeal of Section 377A, which I think, you know, for many of us, we didn't actually think it was going to happen so quickly. You know, I think, in fact, many queer people were saying that they weren't actually sure whether the repeal would happen in their lifetimes, you know, but look where we are. And I think it's really a product of the incredible strategic litigation, the incredible organizing that the queer community, the LGBT activists have been doing for the past 10, 15 years, you know, and in coordination with all the strategic litigation efforts being brought by all the lawyers. But what we're seeing now is quite a unique development, I think, you know, where we have the constitutional amendments coming, you know, that will block any potential judicial review of the definition of marriage in courts, right, on the basis of fundamental liberties. What we're seeing in the text as well is that it goes beyond just the laws defining what marriage is, right? It also goes to executive action that is undertaken to protect or promote the institution of marriage, which is really vague, really overbroad. Effectively can cover, you know, a whole range of anti-LGBT policies, right? And actually, if we look at the explanatory note, it also talks about how this ouster clause will extend to housing, media, and education policies. And so I was wondering whether you could share a little bit about what you think about this. Do you think that this would be a roadblock for future, LGBT activism, organizing in Singapore, and whether or not you think that maybe this is also a bad side product, right? A bad byproduct of the strategic litigation that has been happening in Singapore?
Yeah, that tends to be byproducts of litigation that we may have to contend with. I'm not sure if you are familiar with a case called UKM. So UKM is a case regarding gay adoption, gay parents who had to legally adopt one of their own biological child that they had obtained through surrogacy. It's quite a torturous technical route. It went again to, this one not the Court of Appeal, but to the High Court, but seated by three judges, including the Chief Justice, and through a very complicated route, the Court of Appeal again reasoned that he will be entitled to adopt. But there are certain remarks in that Court of Appeal that would then say that, oh, this is a very one-off situation, and as long as the government articulates some clearer policy in future against gay adoption, the policy of gay adoption, we are not going to a future case like this may very well not succeed. And true enough, after that, government started to put forward certain statements or policies, and now they're really emphasizing this thing about heterosexual units are fundamental unit of society. How one deals with these things? Before I go there, I think that also the clock may be in Singapore. The clock may be turning back a bit also, or in terms of the cycle, maybe turning back a bit, in the sense that, as I was mentioning, in the late 2000s, the courts were, even though they were dismissing things on the merits, they were just receptive. They were saying, please argue, we just want to talk about constitutional law. Now things the tide seem to be turning a little bit because arising from recent death penalty constitutional challenges. So it's again intersectionalities. So you have that, and then the courts have been keep on telling to lawyers, keep sending the message to lawyers. If you bring something which we think is obviously unsustainable, you're going to get personal disciplinary sanction. So this is some blowbacks that I suppose is a natural thing. How one reacts to it, I can't really speak too much about the activism angle, but I suppose from the legal angle, we just have to keep on looking at the little interstices, the little things that we may consider challenging. So you had mentioned that the constitutional amendment not only immunizes legislation, it also immunizes certain executive action and policies. A future case may say that actually that doesn't change the law very much because it's still subject to legislation, it's still subject to the policy of the law, the doctrine of ultra vires still stands. So there's not, if a certain policy or certain executive act is still ultra vires but against the overall policy, there are still many technical arguments that you can still run that's not obviously unsustainable and that's not immunized by the Constitution. From the non-legal side, of course, all this really play a role. I would say that in 2018, what really pushed the activism forward was also many public statements by very prominent lawyers. One was an ex-judge of appeal of the Court of Appeal saying that he personally thinks that it's unconstitutional. There was one, Professor Tomiko, who ambassador at large. And then later on, we are having academic articles by the previous Chief Justice saying that clearly 377A is unconstitutional. So yes, I think a joint effort has to be made, and everybody just needs to be careful and protect each other.
Thank you so much, Swang. Yeah, no, I think you raised many interesting points, right? Including the point about whether or not the ouster clause, if it passes, which we know that it will, because of Singapore's supermajority, whether or not, like from a constitutional perspective, right, whether or not it's even valid. And I think these are the conversations that we see happening in the jurisprudence from the courts, and then sidestepping sometimes the issues of the constitutionality of ouster clauses as well. And who knows, maybe the ouster clauses, if they pass, will be struck down on the basis of them being ultra virus, or maybe even the basic structure doctrine, might make its way into Singapore as well. And I think conversations are starting in the legal fraternity on that, right? Like whether or not these ouster clauses can even stand from a rule of law, from a separation of powers perspective. So thank you so much for that sharing. Yeah. Pass the time over to Ajita, who would ask another question. Yeah.
Thank you. Thank you so much. Akkai, are you still with us? I'm not sure if Akkai is still with us, so maybe I'll pose the question.
Akkai is no longer here.
Okay, so I'll maybe pose the question to CLPR. Do we still have colleagues from CLPR with us? Do we have Sri Raksha from CLPR with us?
Yes.
Hi, thanks for joining us. So Jayna had to leave, but another colleague of ours from CLPR has joined us. Thank you so much for being here.
No worries. Thank you for having me.
Absolutely. So we did have a question for Akkai, but maybe I'll pose Akkai's question and CLPR's question both to you. And since you work very closely with Akkai, maybe you'll have a reflection on both, but feel free to answer just one if you wish to. My question for Akkai was in terms of the Transgender Act that was passed a couple of years back. But despite that, trans people still have to approach the courts ever so often when it comes to accessing rights as basic as the right to food during COVID, like Jayna talked about, but also in terms of getting admission in university spaces, employment spaces. We all know there have been quite a few landmark cases, so to say, in terms of trans people trying to get a pilot's license or work out their employment in the army if they've transitioned while they were still in army. So there have been a lot of these cases of late, especially, and CLPR has been at the forefront of some of those cases. In the context of the Transgender Rights Act having been passed already, what are your reflections on the fact that trans people still have to access the courts all the time when it comes to these cases? And just a follow-up question to that is, in that sense, what is the need, how sustainable do you think strategic impact litigation is in that process?
So to answer your question one by one, as you know, the Trans Act was passed in 2019 and the rules came out in 2020 amid the COVID pandemic situation. There was a lot of backlash from the community themselves because most of the provisions of the act are extremely problematic and violative of whatever the fundamental rights that was enshrined by NALSA. So the act is there. It's a good step forward, but also if you have to identify yourself as a binary gender, you would have to show to the government that you're undergoing any kind of medical intervention. This caused a lot of uproar among the community because that takes away like 10 steps back from what NALSA was, right? So even NALSA talked about reservation. NALSA talked about healthcare being given to transgender community, so among all those. So the Trans Act in itself is not very holistic as to how to make policies. So the act exists, the rules exist, but the modalities of how to implement the act is lacking in overall, right from change of name to like getting basic getting the TG card in itself, which is the transgender card in itself, is such a difficult process because the district magistrate is supposed to issue the card for you to access other rights, but the district magistrate themselves are not sensitized or even aware of what is there in the Trans Act. So that's where the problem begins. Leave alone, going to bigger issues like reservation or access to housing and other schemes. So even the smallest thing that the act promises is becoming problematic. So coming to the question of, strategic, litigation with respect to this. So for example, CLPR represented Jiva, another case where one person horizontal reservation was given to the members of the trans community. So NALSA technically talked about vertical reservations for people of transgender community, but there were so many people from the community who then had to forego their either identity of caste, and had to pick their gender identity, and this caused a lot of problems. So this is where Jiva intervention came, where we filed, and then now Karnataka is the first state in India to provide one person horizontal reservation for trans community, and now that is being followed suit in other states. Like Madras High Court has now recommended, why don't you do it now? On Telangana High Court, where the other case where we are going, Chief Justice looking at why can't we do it. So even though NALSA said vertical, after coming together and listening to the community as to what problems vertical reservation has, one small policy change in a state government is causing ripples across India, and people are trying to think about how else we can give reservation. So the Trans Act alone is not going to help, is what I'm trying to say. That along with, stakeholder partnership, community led, and basically trying to put in place proper accountability mechanism in the act, as well as uh, making it foolproof, the act foolproof. It leaves a lot to the state governments at the end. Like, you have to follow a policy. So how are you going to implement all these non-discrimination policies, or like equal opportunity policies that the act talks about in private sector? The act does not talk about it at all. It just gives you the right, but enforcement is lacking, which is where strategic litigation will come into place. I hope that answer your questions with my limited experience and interaction with the pioneers that I have worked with.
No, thank you so much. And you actually have answered partly the next question as well, which I'm happy to pose to you if you still wanted to reflect on it. My next question to CLPR was going to be about your reflections in terms of being community-led, because that's a unique space that CLPR has been able to carve out. And I just wanted to know, for the benefit of everyone here as well, what has been the impact on your work in terms of strategic litigation, and how has it been impacted by the trans movement in terms of the way that it's defined rights for itself as a movement?
So CLPR usually engages with trans activists and people who are majorly part of the movement, right? For example, down south we have Akkai, we have Grace Banu from Tamil Nadu, then in Telangana we have Jayanti, and up east we have Shanta Kurai, and so many people. So each state has its own problems, right? India is very diverse in that particular aspect. So it was Grace Banu who got our attention with intersection of caste and gender, and she had been in that movement for a long time now. She's been fighting forward with that. So their inputs mean a lot, and even the blood donor guidelines was brought about with one of the trans activists like Shanta Kurai, and all these COVID reliefs, unless, like, for a cis person who's getting the benefits and the schemes of government so easily, being excluded in these small cash reliefs and COVID vaccine, which is extremely important during a pandemic, it would be impossible without trans activists in the community coming forward and giving their inputs. So without that, we are just giving them the law, but what the actual, that, like how Akkai said, their existence is political, their existence is legal, right? That there's so many problems with respect to that. So that's how we started the horizontal reservation, and now trying to see how strategically we can impose that in other high courts that we are challenging, any other discriminatory act when it comes to trans community. So yeah.
Thank you so much, Shiraksha. We really appreciate your comments. And with this, we've now come to an end of the webinar. Thank you so much to all our speakers. This has been truly wonderful, and we hope we can have more of these discussions. We hope this is the first of many. where we can bring lawyers and activists like yourselves together to share your experiences. I know there's a wealth of knowledge that we're all sitting on right now, and it would be absolutely fascinating to hear more about your work, the way you build alliances, the decisions that go into deciding which cases to take to court, and your reflections from both cases that work and the ones that don't. Thank you so much on behalf of ILGA Asia. This has been absolutely wonderful, and I'll pass on the time to Darren now.
Likewise, on behalf of ICJ, I just really wanted to thank all the speakers for your really generous sharing. I think, we could see that there was a lot of head nodding, happening between all the different people who had their cameras on, and I think it really shows how there is so much that we can learn from each other. And I think, a lot of these conversations are already happening, but I think this is a potential platform for us to continue these conversations, for us to learn from each other, learn best practices, learn not so good practices as well, and similarly to Ajita, I think that this can be the first of several more similar such meetings, webinars, and I think we really look forward to engaging with everyone and learning more from everyone. So on behalf of ICJ, thank you so much.
Thank you so much.
Thank you, everyone. In the coming week, we might write to you just to touch base on this webinar, and we'll be sharing a recording with all the participants who registered with us. If there's any questions in the coming week to the participants or to ILGA Asia or to the ICJ, feel free to reach out to me or to Darren, and we'll make sure to answer those questions. Thank you so much. Have a great weekend, and thank you for staying with us till this late an hour. Thanks so much, everyone. Bye-bye.